Good morning. I will now call the Subcommittee on Federal Workforce, U.S. Postal Service, and Labor Policy to order. Today's hearing is on the Hatch Act, Options for Reform. As we do in all our Subcommittee, Oversight Subcommittee, and full committee hearings, I will state the Oversight Committee mission statement. We exist to secure two fundamental principles. First, Americans have a right to know that the money Washington takes from them is well spent. And second, Americans deserve an efficient, effective government that works for them. Our duty on the Oversight and Government Reform Committee is to protect these rights. Our solemn responsibility is to hold government accountable to taxpayers, because taxpayers have a right to know what they get from their government. We will work tirelessly in partnership with citizen watchdogs to deliver the facts to the American people and bring genuine reform to the Federal bureaucracy. This is the mission of the Oversight and Government Reform Committee. I will now recognize myself for an opening statement. During my brief tenure as a member of Congress, I have seen how well-intentioned legislation can have unintended consequences when applied to the real world. This is certainly true with respect to the Hatch Act. Originally enacted in 1939, the Hatch Act was needed to prevent an all too prevalent practice of Federal employees engaging in partisan political activity using Federal resources. The Hatch Act was last amended in 1993, a year in which employees were becoming accustomed to email for workplace communication and using other forms of electronic communication to share information with their colleagues. Technology's advance is only speeding up, and the Hatch Act is in need of update. Today's hearing builds on the committee's June 2011 hearing, at which a bipartisan panel expressed support for making major changes in the Hatch Act statute. Furthermore, several bills have been introduced to repeal the Hatch Act's overreaching and arbitrary restrictions on State and local government workers who seek to run for office. In short, there is a growing consensus that we should enact comprehensive Hatch Act reform. The Federal Government should not be in the business of making personnel policy for State and local government employees, and the Office of Special Counsel should not be dedicating as much of its resources as it now does in pursuing complaints concerning State and local elections. Rather, the Office of Special Counsel should be focused on cracking down on Federal workers who abuse the public trust and on protecting those Federal workers who are unfairly targeted by their managers for blowing the whistle on waste, fraud, and abuse. Instead, we should craft legislation that preserves the intent of the Hatch Act and reflects the realities of today's workplace. Comprehensive reform should, for example, adopt a definition of Federal workplace that accounts for how Federal employees communicate today, which is oftentimes out of the office, on the go, with personal electronic devices. I think we can all agree that our nation's public servants should be prohibited from engaging in partisan political activity. The Hatch Act has been largely successful at curbing overtly partisan politicking within the civil service. However, a fresh look is needed to address certain unforeseen challenges and unintended consequences. We will hear about some of those consequences today, and I hope that we are able to enact changes that prevent them from occurring in the future. I would like to thank Mr. Cummings for his work on the important issue, and I will look forward to working with him, Chairman Issa, and Ranking Subcommittee Member Mr. Lynch on moving Hatch Act reform legislation through the House of Representatives of this Congress. I thank the witnesses for appearing for today, and I look forward to your testimony. I will now recognize the Ranking Member of the full committee, the gentleman from Maryland, Mr. Cummings, for an opening.
Mr. Chairman, thank you for holding this hearing today. In March, I introduced H.R. 4152, the Hatch Act Modernization Act of 2012, which is co-sponsored by every Democratic member of the subcommittee. This bill provides immediate, common sense, and non-controversial fixes to the Hatch Act. Specifically, it implements recommendations for immediate reform proposed by Special Counsel Carolyn Lerner. First, the bill eliminates the restriction that prevents State and local government employees from running for political office. Currently, if a State or local government employee works on a program that receives any amount of Federal funding, the Hatch Act prohibits that employee from running for office. This restriction has led to a number of simply unjust results for public servants. For example, today we will hear from John Greiner, the former police chief for the city of Ogden, Utah, who was removed from his position because he ran for State Senate. In another example, the Philadelphia transit cop was barred from running for his local school board because he works with an explosives detection dog paid for by a grant from the Department of Homeland Security. These results make no sense. Even worse, the Office of Special Counsel reports that 45% of its caseload now involves enforcing this restriction. diverting valuable resources from more critical issues. The Hatch Act Modernization Act also implements a second recommendation made by the Special Counsel. It expands the range of penalties for Hatch Act violations. Right now, an employee who commits a Hatch Act violation, no matter how minor, must be fired unless the Merit Systems Protection Board unanimously votes to impose a lesser penalty. This bill makes it easier for the punishment to be more appropriately fit for the violation. Finally, the bill includes a third provision to treat employees working for the District of Columbia as state and local government employees rather than as federal employees. This provision is based on legislation championed by Congresswoman Eleanor Holmes Norton that passed the House by voice vote in the 111th Congress. We will hear today from the Attorney General of the District of Columbia that without this change, he will not be able to run for another term in 2014. That just does not make sense. Mr. Chairman, this bill is simple, straightforward, and non-controversial. Last June, at our first hearing on the Hatch Act, Chairman Issa, to his credit, said the committee would consider Hatch Act legislation before the election. He said this, and I quote, "The Oversight Committee is intending to author such legislation as may be necessary and will affect the next president. Necessarily, we will, in fact, work on a bipartisan basis to find any and all changes necessary to take effect upon the inauguration of the next president. Although this is 18 months and it seems like a long time, in political time is a very short period." End of quote. The Chairman was right. That was nearly a year ago, and time is running out. Although I support additional efforts to improve the Hatch Act, H.R. 4152 includes common sense fixes that the Special Counsel needs now before the election. These provisions have widespread support, and we can pass them immediately. Mr. Chairman, I'm hoping that we can work together to schedule a markup for May 31st when we return from the Memorial Day recess. There are many public servants, police officers, social workers, paramedics, many who want to serve their country by holding public office. We should not make them wait any longer. And with that, I yield back.
Thank you, Mr. Cummings. Now recognize the gentleman from Massachusetts, the ranking member of the subcommittee, Mr. Lynch, for an opening.
Thank you, Mr. Chairman. I'd also like to welcome our witnesses this morning and thank each of them for being here to help the subcommittee with its work. As the ranking member has pointed out, it's been nearly 2 decades since the Hatch Act was last amended, and throughout this time we've witnessed significant legislative, workplace, and technological developments that collectively have demonstrated a need for us to modernize this essential and landmark law. Accordingly, I welcome this opportunity to examine how we can best bring the Hatch Act up to date, to reflect our contemporary Federal workplace in a responsible and bipartisan manner that also safeguards the integrity and purpose behind the Act. The original Hatch Act of 1939 and its subsequent amendments in 1993 together were intended to curtail on-the-job politics in the Federal workplace. The law itself attempts to walk a fine line between affording maximum respect to the constitutionally protected freedoms of speech and expression and the compelling need to eliminate political coercion and partisan influence throughout the Federal civilian workforce. In other words, the Hatch Act helps to ensure that those government employees tasked with carrying out policies and programming do exactly that, while putting aside their individual political views. As many of you have heard me state on several occasions, I truly believe that the Federal Government has one of the most dedicated and talented employee workforces anywhere in the world. The majority of our workers enter public service with an innate interest in doing right by their fellow citizens and making a positive difference on behalf of their country. Nevertheless, there will always be a few bad actors that unfortunately use their official position to influence or advance a particular political agenda, party, or partisan candidate. In those few cases, we fortunately have the provisions of the Hatch Act to rely upon, as well as the Office of Special Counsel and Merit Systems Protection Board to carry out the duties of enforcement and punishment, respectively. As we prepare ourselves for another major presidential election and campaign cycle, which in many ways is already well underway, I appreciate Special Counsel Carolyn Lerner's renewed focus on ways to enhance and modernize the Hatch Act. With the advent of smartphones, blogging, and other social media and technologies, the Federal workspace is clearly no longer our parents' workplace. To that end, it's common sense that we would be reexamining now the possibility of modernizing provisions of the Hatch Act. In addition to updating the Hatch Act, the Office of Special Counsel has also put forth some reasonable suggestions for modifying the Hatch Act's reach into political activities of government employees on the State and local level. I've heard dozens of instances cited by Ranking Member Cummings and others involving State, county, or municipal workers who are either prevented from pursuing elected office or in some cases even fired because he or she ran for political office while employed in a capacity that was in some way or another connected to Federal dollars. Mr. Chairman, these reports are concerning and reflective of the need to promptly re-examine the Hatch Act in order to reduce the possibility of such unintended consequences. That said, I urge our subcommittee to move swiftly to consider H.R. 4152, the Hatch Act Modernization Act of 2012, which was introduced by my colleague and friend, Mr. Cummings of Maryland. It's sponsored by every single subcommittee member on this side of the aisle. The bill will address a lot of the concerns being discussed here this morning. If there are additional Hatch Act-related changes that the majority would like to see tackled, then at a minimum, H.R. 4152 should serve as the vehicle for accomplishing those changes. Again, I thank each of our witnesses for being here with us today, and I yield back the balance of our time.
Thank you, Mr. Lynch. I'll now introduce our distinguished panel. We have with us the Honorable Carolyn N. Lerner, who is the Special Counsel of the U.S. Office of Special Counsel. We have Ms. Anna Galindo-Marone, who's the Chief of the Hatch Act Unit at the Office of Special Counsel, who's here not to testify, but for technical reference only, I understand. We have the Honorable Irvin Nathans, who is the Attorney General of the District of Columbia, and I'd like to defer to my colleague from Utah, Mr. Chaffetz, to introduce our next guest.
Well, thank you, Mr. Chairman, and I wanted to take just a moment and thank one of our own from Utah, Mr. Greiner, for being here. He began his law enforcement career in Ogden in 1973 and later rose through the ranks and became the Ogden City Police Chief. In fact, in 2005, Mr. Chairman, he was named the Utah Chief of the Year, quite a distinction for somebody who's served law enforcement so nobly for so long. He was elected to serve a 4-year term in the Utah State Senate in 2006. But Mr. Greiner was fired by the Ogden City on December 28, 2011, after a federal panel ruled he violated the Hatch Act. See, Mr. Greiner's violation came when he signed a quarterly report for a federal grant to upgrade the police dispatch system, money that went to the county, not to the actual department. So city officials said the termination was necessary in order for Ogden to continue receiving future federal funds and loans from the Federal Merit Systems Protection Board. Mr. Greiner was not only was fired, but was also banned by the federal government from serving as a law enforcement officer in Utah for 18 months, starting in January of 2012. This is outrageous. It's something that needs to be rectified, and I appreciate the bipartisan support, in particular on this, by these members on this dais today. We appreciate the service of Mr. Greiner. We appreciate you being here. Sorry, sir, that you've had to go through this, but hopefully you can help us as we try to figure out the solution, because I certainly don't think you were part of the problem. Thank you, Mr. Chairman. Yield back.
Thank you, Mr. Chaffetz. Our next witness is Mr. Scott Kofina, who is a partner at Drinker, Biddle, and Reith. And our last witness is Mr. John Adler, who is the National President of the Federal Law Enforcement Officers Association. Pursuant to committee rules, all witnesses will be sworn in before they testify. If you all wouldn't mind rising and raising your right hand. Do you solemnly swear or affirm that the testimony you are about to give this committee will be the truth, the whole truth, and nothing but the truth? Thank you. Please be seated. Let the record reflect that the witnesses answered in the affirmative. In order to allow time for discussion, please limit your testimony to 5 minutes. Your entire written statement, of course, is part of the record. And now I'll recognize Ms. Lerner for an opening.
Thank you, Chairman Ross. Committee. Let me start over. Thank you, Chairman Ross, Ranking Member Lynch, members of the subcommittee. Thank you for the opportunity to testify today about the U.S. Office of Special Counsel's administration of the Hatch Act. And with me today is Anna Galindo-Marone, who's the Chief of OSC's Hatch Act Unit. After being sworn in as Special Counsel last June, I reviewed OSC's Hatch Act program, and I quickly discovered the overreach of this otherwise very important law. At its best, the Hatch Act keeps partisan politics out of the workplace and prevents those in political power from abusing their authority. But at its worst, the Act interferes with the rights of well-qualified citizens to serve their local communities by running for state and local office. This concern, along with others, prompted me to send Congress a legislative proposal to amend the Hatch Act. I applaud the bipartisan group of lawmakers in both the House and the Senate who introduced this legislation in March. The primary reform in these bills is removing the Hatch Act's prohibition on state and local employees running for partisan elective office. Removing this restriction will promote good government and demonstrate respect for the independence of states and localities. It will also let OSC use our very limited resources toward more effective enforcement of the Act. Currently, state and local employees are ineligible to run for office if their jobs are in any way tied to a source of federal funds. Both case law and the substantial increase in federal grant programs have greatly expanded the law's coverage. Hundreds of thousands of public servants, including first responders, healthcare workers, and police officers, are now covered by this prohibition. This expansive application of the law leads to absurd results. Here are some examples. As Representative Cummings noted earlier, OSC recently had to tell Matthew Arlen, a police officer in a K-9 unit, that he couldn't run for the school board because his partner, a black Labrador, is funded through federal grants. Mr. Arlen rightly questioned, how much influence can my dog have over what I could do on the school board? We told a paramedic he couldn't run for county coroner because some of the patients that he transports receive Medicaid. And we routinely advise deputy sheriffs that they can't run for sheriff. Thus, the most qualified candidates are often disqualified from running for office. This is especially a problem in smaller communities where the pool of potential candidates is very limited. But not only is the reach of the Hatch Act too broad, its enforcement often leads to inconsistent and unfair results for several reasons. First, OSC can only investigate those cases where it receives a complaint. So using the Hatch Act as a weapon, candidates frequently file complaints against their opponents. An allegation that an individual is in violation of federal law, even in the absence of any wrongdoing, can cast a cloud over a candidacy. Our enforcement efforts actually increase the level of partisanship in politically charged contests. Second, OSC has no jurisdiction in nonpartisan elections. This exemption creates confusing and inconsistent results between neighboring localities. For example, a school board election may be partisan in one county, but nonpartisan the next county over. One final example. The law does not apply to elected officials. And once someone has already been elected to office, they are free to run again in any partisan election. This again leads to absurd results. Like a deputy sheriff who can't run against a sitting sheriff, but that sheriff could run again not only for that office, but any other elected office for which he may choose. These arbitrary results reinforce the need to let states and localities decide how best to restrict the political activity of their employees. In fact, each state already has their own ethics rules, or mini Hatch Acts, covering this issue. Despite my concerns about the unfair application of the Act, nearly half of OSC's Hatch Act caseload is made up of state and local cases. Over the past 2 years, we've conducted more than 500 investigations and issued thousands of advisory opinions. In these cases, we must conduct very fact-specific, time-consuming investigations to determine coverage. And the state or local agency has to spend their resources answering our document requests and interview requests. It's important to note that if the candidacy provision is removed, a state or local employee still could not engage in coercive conduct or misuse their authority for political gain. Without the candidacy provision, though, OSC could target its resources on these types of cases in which actual misconduct is at issue. We could also do more outreach and education to help employees understand their obligations under the Act and prevent problems from happening in the first place. A second important reform is modifying the penalty for federal employees. As the law now stands, termination is the only penalty unless the MSPB, the Merit Systems Protection Board, unanimously votes to mitigate the penalty. But even in these cases, the MSPB can't impose a penalty of less than 30-day suspension. This structure is overly restrictive and can lead to unjust results. It can even deter agencies from referring potential violations to my agency because they don't want to lose an otherwise good employee. The pending legislation allows for the same range of penalties which now apply to other disciplinary actions, and passing this reform will aid OSC's enforcement efforts. Finally, we have noted several other potential areas for legislative reform of the Hatch Act. These are described at greater length in my written testimony, and given my time constraints, I'm going to rely on that submission. I also know that other panel members will be addressing several of them. But very briefly, they include the following 5 issues. 1, codify a definition of political activity. 2, clarify the definition of the term federal workplace. 3, clarify the scope of the exemption for high-level administration or White House employees. 4, modify the Hatch Act's application to District of Columbia employees. And 5, consider a statute of limitations. These other areas, I just want to note, are nowhere near as critical, in my mind, as the need to modify the state and local candidacy provision. I really want to stress that that is our most crucial need. And while the other items are important, I really hope that we can emphasize change in that area.
Thank you, Ms. Lerner. I appreciate that. And just as a reminder, panelists, of course, your written testimony is part of the record, so it is all inclusive here. With that, I'd like to recognize Mr. Nathan for 5 minutes for an opening.
Good morning, Mr. Chairman and subcommittee members. I'm Irv Nathan, the Attorney General for the District of Columbia. I'm very pleased I was invited here today to testify about proposals to reform the Hatch Act and to speak in favor of reforms that would treat the citizens of the District of Columbia like the citizens of all states and localities across the country, allowing them to choose their elected officials, whether in partisan or nonpartisan elections, without inappropriate federal restrictions. First, as a former general counsel of the House, let me say how pleased I am to be back here at an institution for which I have such respect and admiration. And let me also comment as a person who has seen a lot of hearings that this is one of the rare hearings where everything that has been said on both sides of the aisle we agree with, and I believe that you agree with each other, and I certainly hope that we can get these reforms passed. It's very important for the District of Columbia residents and for citizens around the country. The short of it is that under the Hatch Act, the current way, the District of Columbia employees are treated just like a federal agency, which is completely inappropriate. And it has had very damaging effects. We have a number of elected officials, one of whom is on the dais, and I'm pleased to see Ms. Norton here today. And we have elected ANC members, we have elected school board members, and as I've testified, as is my statement, now the Attorney General's position will become an elective position starting in 2014. And as it stands, since we're treated as a federal agency, it means that people in those positions are not allowed to run for elective office in a partisan election. And so, as an example, our ANC members are unpaid. These are private individuals. They're unpaid. They're volunteers. They serve their neighborhoods. They serve the district. But because they are considered office holders under the Hatch Act, they are precluded from running for partisan office. They can't run for the city council. They can't run for mayor. They can't run for our congressperson spot. Similarly, our school board is in the same posture. They can't run. They're elected on nonpartisan basis, but they can't run in partisan elections. And as it applies to the Attorney General position, I was appointed by the mayor. This was an appointive position beginning in 2011 when I first was appointed. It has now become an elective position in a partisan election. It means if I wanted to run for this office, or more appropriately, if some of my senior deputies who have been there for years want to run for this position, they are not permitted to under the Hatch Act. And even more preposterously, if someone runs and is elected to the Attorney General position this term, if that person wanted to run for re-election, they would have to resign before they could run for re-election, a loss to the public and something that makes no sense. So the solution we suggest is to pass the reforms that Congressman Cummings and his colleagues have proposed, and also to make clear that District of Columbia employees shouldn't all be lumped together. We also have judges and folks who work in the City Council, which is an elected position as well, and they should not be covered by the Hatch Act. It should be for executive branch employees. We certainly support the basic notions of the Hatch Act. We're not looking for anybody to pressure or engage in partisan activities in carrying out their positions, but by not permitting them to run for election, you are depriving our electorate of their choices, of people who are well qualified, and you are depriving people who are in good position to help the city from running for election. So we urge you to modify the Hatch Act to pass the reforms that have been proposed and to make the tweak that, as it applies to the District of Columbia, we be treated like state or local government officials, and that it only apply to executive branch officials within the district government. Thank you very much.
Thank you, Mr. Nathan. I now recognize Mr. Greiner for 5 minutes for an opening.
Good morning, Mr. Ross, Chairman and members of the Committee on Oversight and Government Reform. My name is John Greiner, former police chief of Ogden City, Utah, former Utah State Senator, and Hatch Act violator. I appreciate the opportunity to appear before you today and discuss my experience with the Office of Special Counsel and their enforcement of the Hatch Act. In early March 2006, I was recruited to run for the Utah State Senate by a number of legislators and representatives of the Utah Attorney General's office. I scheduled time with the Ogden mayor and city attorney to talk about the city's position on the matter in the final days of the candidate filing period as their employee, and get their approval, as this service is determined by them to be in the best interest of the residents of Ogden City. On about October 3rd, 2006, I was contacted by phone by an attorney of the Office of Special Counsel about an anonymous complaint allegedly filed against me regarding a potential Hatch Act violation. She asked that I summarize the current police department grants in a letter back to her. I sent her an email with that summary. Over the next couple of weeks, we respond back and forth to give her everything that she's needing to conduct her investigation. She sends me a letter towards the end of October saying that she believes I'm in violation of the Hatch Act. To wit, we hire attorneys and get started trying to figure out what the encompassing part of all of this means. The best case law we can find at the time was a recent decision about a year old involving an assistant police chief named Richard Perkins out of Henderson, Nevada. We contact him, we contact others, we go through the limited amount of paperwork we can find in 2006, try to come into compliance with what the request for the Office of Special Counsel is all about. By the 3rd of November, there was a response from the Office of Special Counsel's office outlining their desire to have me get out of the race or give up my job as a police chief. We respond back to them, trying to understand and trying to work things out to no avail. They tell us in the correspondence towards the end of October of that year that they may seek a complaint against me and the city of Ogden. I had suspended my campaign and tried to work through all of this to no avail. There was absolutely no negotiation with the Office of Special Counsel. There was nothing that they wished to discuss with our attorneys. And so we went through the election and I was elected. 2 years later, we were put on notice that they are going to come after the city of Ogden for allowing me to run for elective office. There's a hearing before an administrative law judge in early 2009. And again, the attorneys in the state of Utah don't understand the act. It became an issue of whether, do we get discovery? Do we get to have witnesses? Do we get to have anything at a hearing before a body of a judge or others? And we got nothing. So we appeal the conviction of the ALJ to the Merit Service Commission, and in a decision, 2-1 decision in November of 2011, they ruled that the ALJ was correct in her interpretation of the Hatch Act law and directed my termination from the city happen by the end of 2011, or the city forfeit 2 years of my salary as a penalty in future grant money. To that point, there were hundreds of pages of legal documents on both sides of this issue, outlining the selective enforcement and the misunderstanding by the state attorneys. There were several hundred thousands of dollars in attorney's fees spent to try and understand the public good of this civil law as it impacts state and local government without any considerations of the mitigating circumstances, including are the penalties as outlined by Representative Chaffetz to myself. I cannot have an executive position in the state of Utah in law enforcement as a prohibition for 18 months. That exceeds penalties federal courts give to convicted felons who have committed crimes which jail is a possible remedy. I offer up Barry Bonds, 30 days house arrest and a $4,000 fine for lying to a federal grand jury. That penalty is minimal in comparison to what the Hatch Act has imposed on me for nothing more than being a point of contact in a grant for which the City of Ogden's Police Department didn't receive 1 penny. Thank you for your time, and I'm prepared to answer any questions you may have.
Thank you, Mr. Greiner. Mr. Kafina, you're recognized for 5 minutes for an opening.
Chairman Ross, Ranking Member Lynch, and distinguished members of the subcommittee, my name is Scott Kafina, and I appreciate the opportunity to share my thoughts on reform of the Hatch Act. As a former Associate Counsel for President George W. Bush, whose responsibilities included advising and training the White House staff on the parameters of the Hatch Act, and as a former staffer in President Reagan's Office of Political Affairs who had to work under its restrictions, I applaud this committee's efforts to enact sensible changes to this law. The Hatch Act serves a very important purpose for our federal government, freeing the government workplace from partisan political influence and coercion. The Hatch Act thus protects federal workers from political pressure when performing their jobs and benefits the public by delivering performance that is free from partisan political influence. Still, the benefits of the Hatch Act come with a price. Its restrictions on political activity implicate the First Amendment rights of millions of federal employees as well as those of state and local government officials whose jobs are funded, at least in part, with federal dollars. Because political activity is at the heart of First Amendment protection, restrictions on political activities must be carefully considered to be sure that they serve the purpose of keeping the government workplace free of partisan political influence and corruption. It was in this spirit that the last significant overhaul of the Hatch Act was enacted in 1993. The 1993 amendments dramatically loosened the restrictions of the Hatch Act that essentially locked government employees out of the political process entirely. With a laudable focus on protecting the integrity of the government workplace, the changes enacted in 1993 struck the appropriate balance by allowing most federal employees to engage in political activity while off-duty, while maintaining strict restrictions on political activity within the government workplace. The Office of Special Counsel has done a commendable job of trying to maintain that balance between the First Amendment and its mandate to enforce the Hatch Act and provide guidance to government employees on what the law does and does not permit. Its program of providing advisory opinions gives practical, timely guidance to prudent government employees or counsel who ask questions before engaging in conduct about which the law is unclear. Still, in recent years, we have seen ambiguities in the Hatch Act lead to confusion in government ranks and uneven enforcement by the Office of Special Counsel. In addition, a lot has changed over 20 years, and the time is right to consider amending the law to address its ambiguities, to keep pace with technology, and to address the areas where the law does not work well or doesn't meaningfully serve its purposes. The touchstone of reform ought to be striking the right balance between First Amendment rights and reinforcing those provisions of the Hatch Act that most serve its goals, namely that federal employees may not use their official authority or influence to interfere with the outcome of an election, may not solicit or accept political contributions, may not pressure subordinates or colleagues to engage in political activity, may not solicit or encourage political activity by anyone within the business before their agency, and may not use official resources towards political ends. With these principles in mind, I believe that necessary and sensible Hatch Act reform would include the following changes. 1. Lift the prohibition on state and local employees running for office. All three of the bills proposed so far include this common sense reform. This arbitrary restriction only on state and local officials whose jobs are supported by federal funds taxes the resources of the Special Counsel without appreciably advancing the goals of the Hatch Act. 2, introduce graduated sanctions to address minor infractions as proposed by Representative Cummings. Most government employees try to play by the rules. If they mistakenly wear a campaign button in the office, a warning should be sufficient to vindicate the law. 3, treat outside political communications during the workday from personal smartphones and BlackBerries in the same manner as personal phone calls and emails. Technology has made it possible to quickly send political messages to outsiders without using government resources or significantly disrupting the sender's workday. It has also made the requirement that an employee leave their federal building to do so impractical and unenforceable. So political communications should be permitted in the same manner that personal calls are permitted, as long as they are not excessive, are not directed to other employees, or otherwise violate the Hatch Act. 4, Federal employees who wish to post permissible political messages on blogs or social media pages should not have their government title appear on those pages, even if only in their profile. In my view, there is too much risk that the title will lend undue weight to the otherwise personal political views of the employee. Similarly, government employees whose title appears on their social media pages should be responsible to remove any political fundraising solicitations placed on their page by others within a reasonable time. 5, the definition of who is included in the relaxed restrictions for certain White House employees and senior government officials should be clarified. First, there should be a presumption that all appointed White House employees fall within the relaxed restrictions. Second, all White House employees, except perhaps those in the national security area, should be permitted to assist the President and Vice President in their political activities. Under the standards employed by the Office of Special Counsel in its January 2011 report on the Bush administration, only high-level White House employees can assist the President with the preparation and execution of a political trip, which simply is not practical. And 6, and finally, recent controversy involving both parties demonstrates the importance of properly allocating the costs of political and official events to ensure that the public is not underwriting political activities. The classification of events as official or political should be done primarily according to objective criteria about the origin and execution of the events, rather than focusing on the subjective motivation behind them. Some questions aimed at evaluating these events objectively are set forth in my written testimony. Once again, I appreciate the committee's bipartisan efforts for meaningful Hatch Act reform and the opportunity to share my thoughts with you today, and I'd be happy to address any questions you might have.
Thank you, Mr. Kofina. Mr. Adler, you're recognized for 5 minutes for an opening.
Thank you, Chairman Ross, Ranking Member Lynch, distinguished members. This is a rare instance for me where I actually agree with everyone on my panel. Therefore, I don't think I don't want to waste everyone's time by sort of restating what was already said, and I'm proud that everyone is working so well together to address this important issue. I mean, the main theme here, what we're looking at, is we don't want the Hatch Act to become a Hatchet Act. And I think, based on the recommendations expressed, we're definitely going in the right direction. I think the Hatch Act Modernization Act, as put forth by Ranking Member Cummings, is on point. It's a proactive effort to address the serious issues, from my perspective and my membership, representing 26,000 members of the Federal law enforcement community, the concerns in terms of the penalties. You know, as Mr. Kofina stated, having those lesser penalties to address an issue of a button or a screensaver or something where technically it might be a violation of the current statute, but it doesn't rise to the level of termination, and certainly it should ease the resource pressures on Ms. Lerner and her very well-organized staff. So having said that, I think it's more important to yield my time so that we can get to questions and other comments that are relevant towards moving this forward to a collective understanding and a proper conclusion. And I'm here to answer any questions. Thank you.
Thank you, Mr. Adler, and I also want to echo your sentiments about the cooperation, especially with my colleagues and Ranking Member Cummings for his bill in this regard. Ms. Lerner, with regard to investigations under the Hatch Act violations, how much money does the OSC spend annually investigating state and local Hatch Act claims?
It's tough to put a number on it. I can tell you our agency's entire budget is around $18.5 million. We have about 110 employees altogether, and we have 8 employees in our Hatch Act unit. Our whole agency gets about 4,600 individual cases per year through all of our program areas, all
right.
4. In our Hatch Act, and the numbers are going up pretty significantly. We've had a 10% increase.
Would you say exponentially?
Yeah, I mean, we are seeing exponential growth in every single one of our program areas. So
in terms of
really
complaints?
Stretched. In terms of complaints. In the Hatch Act unit, in every one of our units. We also do disclosures. We do use SARO. We do prohibited personnel practices like retaliation.
Right.
So we're really stretched.
So could you pinpoint dollar-wise? I mean, is it hard?
You know, I really hesitate to put a dollar number on it. I can give you specific numbers about the number of cases that we have in our Hatch Act unit.
Would you say that there's the state and local Hatch Act workload is greater than, equal to, or less than for Federal Hatch Act violation investigation?
It's about 45% of our entire Hatch Act load. Our Hatch Act load right now is over 1,000 cases, Federal, state, and local. every year, and about 3,000 advisory opinions every year.
Would you say that the state and local investigation under the Hatch Act is interfering with the federal?
Absolutely.
No question about it?
Absolutely. And you know, we have serious cases, you know, the coercion cases, the misconduct cases. And as I mentioned, where I really like to be able to put some resources is in the education and outreach so we can prevent these things from happening in the first place. So many people, I mean, we heard testimony today, people don't understand the Hatch Act. And if we're going to hold employees responsible for being in compliance, then we have an obligation to them to do some outreach and education.
Another aspect of the Hatch Act I think that's disconcerting to me, and especially this being an election year, have you found that the candidates for political office use the Hatch Act against each other
Sure.
During these elections?
Absolutely.
Is it pretty prevalent?
I'd say it is. We're seeing both. We're seeing this happen at both the individual level, where individual candidates, we often get complaints from an opponent in a political race.
In fact,
and it's not just Republican versus Democrat. Sometimes it's in the primary. You know, a Democrat will file a complaint against a fellow Democrat.
Right.
Or a political organization.
And the mere allegation alone is damaging enough, regardless
Absolutely.
of the substance.
Absolutely.
I understand that there's an OSC investigation involving Secretary Sebelius with regard to a gubernatorial campaign. Do you know what the status of that investigation is?
You know, we've talked with your staff about the status of that investigation, which has been reported publicly. We received Chairman Iss's letter, which alleged a potential violation of the Hatch Act. As I mentioned, we discussed this with the committee prior to the hearing, but in accordance with our policy, I can't really add anything further at this time.
Can you comment on as to when you think that report might be issued? Or
It's being actively investigated, and I hesitate to give you a date that may or may not be right. Okay. But we're putting resources. You know, as I mentioned, we have 8 lawyers to cover all of our Hatch Act cases, but we're making this one obviously a priority, and we'll get through it as very quickly as we can.
Thank you. Mr. Greiner, with regard to the allegations against you and the violations found, specifically, what was the amount of the grants involved?
I could go back on each of the grants. There were 4 grants. They were all multi-jurisdictional kind of grants because we try to do that to get the grants. But the grant that was the focal point of the decision by the ALJ was a $400,000 grant for a dispatch center that had nothing to do with the police department. I mean, certainly we get the benefit of the dispatch center being there, but it was a cooperative effort that was put together to try and get some grant money for state communication sites to improve the connection between police and fire departments in 2 counties. And we already had built a new building with that piece
so
there.
Upon receipt of the grant money, did you have any control over where it went?
No, and not one penny came to the police department that I managed.
So you had absolutely no authority over the delivery of or distribution of the grant money?
Not one penny.
And you talked about several $100,000 with regard to lawyer fees involved. How much did it personally cost you for this, to defend yourself in this confrontation?
I was out of pocket over $30,000 personally before the Office of Special Counsel filed a complaint against the city, and then the city picked up the remainder of the tab.
Thank you. My time has expired. I now recognize the ranking member of the full committee, Mr. Cummings from Maryland.
Thank you very much, Mr. Chairman. Mr. Lerner, on March 7th, I introduced the Hatch Act Modernization Act. This legislation implements 2 recommendations the Special Counsel made for immediate reform. First, the legislation eliminates the Hatch Act prohibition on state and local government employees running for office. I understand that's very important to you. And this would take the federal government out of the business of telling state and local government employees, such as Mr. Greiner, whether they can serve their country by running for elected office. Mr. Lerner, can you explain why eliminating this provision is so important to you and your office?
Sure. I'd like to just start, though, by thanking you, Chairman Cummings, for introducing the Hatch Act legislation. I appreciate that very much, and your efforts are truly appreciated. The reason that this is so important, as I mentioned in my opening statement, there are a number of reasons that the state and local provision is so important to my office. I mean, first is just from a standpoint of fairness. I don't think I've talked to anybody, you know, either here in Congress or, you know, in government who thinks that it's fair that people can't serve their local communities just because they're employed by a state or local government that receives some money, and it can be a very small amount, or they can just be touched by federal funds. So there doesn't have to be a strong connection, and then they can't serve, they can't run for office. And so there's first the issue of fairness. Is this really something that we want to do? And as a federal government, is it the proper role for us to be telling state and local governments how their employees should behave? And as I also mentioned, most states have their own rules that would cover this issue. They have either mini Hatch Acts or ethics rules. I think it's appropriate for those states and localities to enforce prohibitions on their own employees.
Well, when you look at those, I'm sure you've taken a look at those state provisions. Would they serve this? I mean, there was an intent when this Hatch Act was developed to address certain issues. And I guess what I'm trying to figure out is, have circumstances changed over time and they become outdated? And then if the states are doing this, what's the difference between what the state is doing and what the feds are doing now? You follow me?
I am. I think what has happened since this act was first enacted and since it's been amended is that there's been an influx of federal funds into the states, particularly after 9/11 in the law enforcement area. So now virtually every law enforcement agency on the state and local level receives some federal funds. So there's the breadth of this act is much, much larger than it was ever intended. In terms of the actual, I mean, there's sort of three parts to this. One is the running for partisan political office, and that's the only thing that the legislation would strongly affect. The coercion issue and the improper use of office will still be there, and so we'd have enforcement ability in those two areas. But there is, as far as I can see, no real purpose in saying that someone can't run for office just because they happen to work for a state or local government that receives some federal funds, or that their job is touched by some federal funds.
But what was the original intent? Was it to try to block people from running for office? I mean, you understand what I'm saying? Was it that people that were in office were saying, well, look, we don't want people running against us? Are you following what I'm saying?
I think the original intent was to try and keep politics out of the civil service. Mm-hmm. And frankly, it's having the opposite effect now. It's becoming much more politicized because of this provision. And I think it was just never intended to do that, and these consequences were unforeseen at the time.
So you're seeing situations where you look at, you've got a law, you got to enforce it, but you yourself look at it and say, wait a minute, there's something awfully wrong here.
Yep. Within a couple months of my taking office in June, I was having conversations, I think, with both you and Chairman Issa about this law, and we sent over some proposed legislation in October to try and resolve it. It just, we're gonna enforce the law, and the way the law reads right now, it's not something I'm particularly comfortable doing, but we're going to enforce it because that's our job. But I sure hope you all can change it.
Thank you. Thank you, Mr. Chairman, for your courtesy, too. I really appreciate it.
Thank you. Now recognize the gentleman from Massachusetts, the ranking member of the subcommittee, Mr. Lynch, for 5 minutes.
Thank you, Mr. Chairman. Mr. Adler, I want to thank all the witnesses. It is unusual that we get a whole panel that basically agrees, and as well, that agreement is reflected up here on the dais. So since we're all in agreement that this is a good idea, we'll probably have to kick it upstairs to party leadership, and they'll come up with some reasons why we really don't agree, because this can't happen. Mr. Adler, first of all, I want to acknowledge that this is actually National Police and Peace Officer Week, and from the dais on both sides, we just want to acknowledge the fact that you and your members just do some terrific work in protecting us and the government, the Capitol, and also the Federal Government and the nation. And we appreciate the risk that you confront every single day. And these have been some tough months for law enforcement all across the country. And Our prayers and our thoughts go out to you and your members, and we really appreciate the work that you do every day. You were very economic in your remarks initially, so I've got to punish you for that. In terms of education on the Hatch Act, and as Council Lerner has pointed out, after 9/11, a lot of federal money got pushed out to both police and fire grants, cops grants, so that now this connection, however tenuous it might be, is there and precludes people from running for office, and other limitations put on you as well. How do your folks get educated on the Hatch Act? Do they get advised in advance, or is it when they trip up, then all of a sudden it comes down on them?
Maybe it's a whisper in advance. Now, I think that we could learn from the other areas of training that we get by way of ethics, sexual harassment, computer security, where we get these online training sessions where we can actually see something. And I think typically what happens is, whether it comes down from the Attorney General or there is some memo that will come down prior to an election, right about now, that gets circulated. And it could be a 3-page, a 4-page, a 5-page letter, font size probably 8, which is a challenge for me. And although it may be well written and thorough, it doesn't exactly rise to the same level or the same effect that the other types of training the government delivers, again, by way of ethics training and other areas of importance. So I think, as Ms. Lerner said, there is an absolute need for better outreach and education. I think certainly, we could use examples. I mean, there are things that, and Mr. Kofina hit upon it, whether it's a screensaver issue, it's a Facebook posting. We have now people authorized to work out of their home. So if they, during their lunch period at home, which I guess they decide, they go on their computer and make a Facebook entry, do they really understand what they're doing? I mean, I think in general everyone has a sort of broad sense as to what the Hatch Act is, but when you break it down, and as Ms. Lerner made clear, we're putting her on the spot when someone technically violates the Hatch Act, unwittingly, that they're subject to termination, which is unfair and unreasonable.
Right. And by having a graduated penalty process where some of this minor, very minor, the wearing the pin, as Mr. Kofina indicated, it's the death penalty. It's basically severance from employment is what that has to happen. So that graduated penalty process may be a warning, take the button off, that type of thing. Would certainly lighten the load for Ms. Lerner and her staff. And I don't know, this all seems to be common sense. You'd think that, we should be able to come up with these modest and, I think, very sound recommendations. I'm going to suspend as well. Thank you. I yield back.
Thank you, Mr. Lynch. Now recognize the gentlelady from the District of Columbia, Ms. Norton, for 5 minutes.
Thank you very much, Mr. Chairman, and I appreciate that you've invited a witness from the District of Columbia so that we can, and a particularly well-qualified witness so that we can get to this long-standing issue. Indeed, this House actually, I think my first term in Congress actually changed the Hatch Act not to apply to the district, Federal Hatch Act not to apply to the district. The bill did not pass the Senate, and here we are again, more than 20 years later. Mr. Nathan, do I understand you at page 6 you say, I stated earlier, legislation should be amended so that similar to Congress, the Hatch Act does not apply to the district's legislative or judicial branches. Do you have any do you have any issue with the legislation with respect to the District of Columbia as it is now framed in the statute, in the bill, excuse me?
In the bill, we support the bill, which would move the District of Columbia to away from being treated as a federal agency and being treated more like a state and local jurisdiction, and obviously allowing people to run in partisan elections. I think it could be tweaked to make it clear that when it talks of the D.C. government, it's talking about the executive branch of the D.C. government, and we'd be prepared to supply some language to that effect, because the Federal Hatch Act doesn't apply to the judiciary or to legislative personnel, not only members of Congress but staff as well, and I think it ought to be parallel.
I'd appreciate receiving your suggestions
delighted
on
to do
that modification. Ms. Kafina, I must tell you, you waded into an area here that I don't envy you for doing, and that has to do with the president and his employees as they make trips during campaign season. I must tell you, it reminded me of what we go through here when we're putting out a newsletter, and we have to go and see what words can be used or not used, and it is a painful exercise. I must say, you speak about the president's trip on student loans, I think.
You may be talking about
Mr.
Kofina.
Oh, Mr. Kafina, I'm sorry. Yeah, on student loans. Here we get into a subject that comes up during every election. It is perhaps the most partisan of issues. You suggested there's a way to somehow thread this needle, and I think it's important that you point out examples that are indeed troublesome. You know, in the case of student loans, this was a matter that was not in the Republican budget at all, and the president kind of barnstormed where you might expect him to student campuses and discussed this issue. It was the first time the issue had been discussed in the Congress. It was a profoundly official issue, and you say, I think quite with great fairness, that this matter is subjective, second guessing, but you do suggest that there are ways to solve it. I have my doubts, Mr. Kafina, because you indicate that there's an authoritative legal opinion from 1982. And I can tell you, I don't think anybody can find any campaign since 1982 where this was not a major issue for the other side. So I have my doubts about what to do about it. And your notion about the theme of the remarks was the official pre-existing or not? Again, I'm struck with how this might be quite unenforceable. And I hate to see something that may be a violation not be tagged, but I must say there's got to be a way other than going through a list the way we do when we go to franking to see if that word or this word should have been used, or if that detour or that, or why did they do this, or was it because of this or that reason. It strikes me that we're into a thorn here, and I'd like to know if you really think that these suggested notions of how to evaluate whether the trip is political or not. Do you suggest that they haven't been used? Has anybody ever sought to enforce these? Has there ever been any enforcement action that anybody paid attention to?
Congresswoman, I certainly personally sympathize with the complexity that you've described, having dealt with this myself when I worked in the White House, trying to sort out, as I had events and expenses that I needed to approve, is this political, is this official, and what are the standards to apply? It is very difficult. Unfortunately, the current standards in place for it don't go anything beyond saying it's a subjective evaluation. It must necessarily turn on the facts. What I tried to do in my testimony, in my written testimony, was introduce and reflect the objective criteria that I tried to apply when I was making these determinations myself. Understanding that, subjective motivation and where did this event come from is a part of it, but there are certain yes or no questions that you can ask to try to say which is the better way to classify this, what is the better way to make sure that the expenses for this trip are properly borne by the public or properly borne by a political party. And so I was looking for, again, objective criteria that might help guide that.
But Mr. Kafina, you say you tried to use these criteria when you yourself were in the White House. Were you able to use them? Did others in the White House use them? Were they useful then?
I found them, yes, to be useful. I found that in evaluating, for example, and this was an issue in the Office of Special Counsel's report from 2011, if an event originated from a member's, if a surrogate event took place in a district of a incumbent, and the question was, is this politically motivated to help the incumbent? Well, one of the questions, and this is an objective question, where did the event come from? Where did the request come from? Did the member's official office invite the president or a surrogate to participate in that local official event, or did it come and originate within a campaign staff?
Unfortunately, the gentlelady's time has expired, but we will be able to supplement the record with questions to the panel as well. With that, I'll recognize the gentleman from Virginia, Mr. Connolly, for 5 minutes.
Thank you, Mr. Chairman, and thank you to the panel with some thought-provoking testimony. Ms. Lerner, you heard Mr. Kafina enumerate a number of what he's characterized as practical, common-sense changes to the Hatch Act that would make it more workable. Your reaction to his list, enumerated list?
Well, on the travel, turn my speaker on. In the category of political travel, I want to just note that we did issue a very extensive, thorough advisory this past fall on October 6, 2011. Put a lot of thought into how best to give guidance to the government and to employees about political travel. And I think that that really has, in many ways, moved the ball forward and provided the type of clarity that's been needed. Ms. Galinda Marone can address that issue a little bit more as well.
But did you have any major exceptions to Mr. Kafina's list? You've already testified you want to see changes to the Hatch Act.
I do. You know, I have to tell you, quite honestly, we're not seeing a lot of cases about these other peripheral issues, the political travel, the social media. Frankly, the Facebook stuff just hasn't been an issue. Email is a little bit more of an issue. You know, we're on the social media issue. You know, certainly the Internet and social media have dramatically changed the way we gather and share information, and the way Federal employees use it has implications. But as an enforcement issue, it really hasn't been much of an issue. We've maybe had 2 or 3 of these cases.
Okay. In response to Mr. Cummings' question to you, he asked, you know, why does the Hatch Act cover state and local government? What was the thinking? Your response was, I think the thinking was to try to protect civil service from partisan overt political activity. And God knows, you know, we have seen in American history state and local governments used as instruments of a political machine or organization or even candidate. So that goal might be a worthwhile one. But the question is, do we need a Federal umbrella to be dictating to state and local governments how they want to conduct their own business? Did I understand your answer? You said that was the purpose, and then you said, but it seems to have the opposite of the desired effect. What did you mean? What's the opposite? I mean, are state and local governments being taken over by political machines?
Well, let me clarify that the only aspect of the state and local candidacy provision that we're advocating to reform is the ability for folks to run for election, partisan political election. They can already run for nonpartisan cases or positions. Coercion matters would still be within our jurisdiction. Improper use of political office would still be covered. So the stuff that I think was originally intended to be covered on the state and local level would not be affected at all. The reason that the running for partisan political office is creating a lot more angst is because it's being used primarily as a weapon. we can only take on those cases when a complaint is filed with our office. We don't go out looking for them. And the folks who file these complaints, for the most part, are political opponents. And it's coming within party. So in a primary, a Democrat could file a complaint against a fellow Democrat who they're running against.
Just an observation, running for partisan political activity as opposed to running for nonpartisan political activity. In Virginia, many cities and many towns run ostensibly on a nonpartisan basis, getting around the Hatch Act. And it is an enormous fiction everybody understands. For example, Mr. Cantor, the majority leader in this House, one of his key aides is an elected official in Fairfax City, in my district, does a good job. But there's no fiction about what party affiliation he has and what he does in his day job. And so while it's a useful tool, I guess, to get around the Hatch Act, I'm not sure it actually achieves the desired outcome.
Well, the mayor of Chicago is a nonpartisan election.
Yes, he is. He's very nonpartisan.
You know, so well,
I know him personally.
Whoever happens to be in that position at the time. You raise a really important point, and it creates this feeling of unfairness. You know, why do we, and we've gotten lots of complaints from folks saying, well, you didn't tell the person in the county over that they couldn't run, and they work for the government. You know, we get a lot of those complaints, and we have to say, we're really sorry, but in that county, school board is nonpartisan. And it creates this feeling about, you know, arbitrariness and unfairness. It shouldn't matter what county you live in.
Thank you, Mr. Chairman.
Thank you. Before I recognize our next member, I recognize Mr. Lynch for submission of a report.
Thank you, Mr. Chairman. I would ask unanimous consent that the committee may accept this testimony of the Hatch Act, options of reform, options for reform, statement submitted for the record by the Federal Managers Association.
Without objection, shall it be made part of the record? Thank you. I now recognize the gentleman from South Carolina, Mr. Gowdy, for 5 minutes.
Thank you, Mr. Chairman. Mr. Chairman, it's been 15 years since I was subject to the Hatch Act, so forgive me if I'm playing catch-up a little bit. Who would be the most knowledgeable panel member for me to pose my question to?
Ms. Lerner.
Depends what your question's about.
Well, it's kind of remedial. My understanding is executive branch employees may not solicit campaign contributions from their peers.
That's right.
And are there any exceptions to that?
I'm actually going to punt this one to Anna Galinda Marone, who's the chief of our Hatch Act unit and knows every detail about how the Hatch Act affects federal employees. And
That
she
sounds
can
like
answer
a
that.
great person to punt it to. Are there any exceptions to that general rule?
Good morning.
Good morning.
Congressman. First, the solicitation prohibition is broader than just prohibiting federal employees from soliciting other colleagues. The prohibition extends to anyone. So no federal employee in the executive branch can solicit, accept, or receive political contributions. The one exception concerns federal labor organizations and federal employee organizations.
That's what I thought. Why that exception?
Not sure the reason why.
You were just described as the most knowledgeable person on this issue. If you can't tell me why there's an exception for federal labor organizations, who can I ask?
Well, I reviewed very briefly last night in preparation for this, the legislative history, and it is somewhat scant in terms of what Congress was thinking when the exception was introduced. Now, it does have some limitations, so there's some qualifiers in terms of the exception, if you want me to go over that.
Sure.
So the federal labor organizations, although the members of those groups can solicit, they still cannot solicit, accept, or receive while on duty or in the federal workplace. The solicitation
is there something called official time?
Correct, but under the Hatch Act, even official time, union official time, is considered on duty for purposes of the Hatch Act, meaning...
So you still can't solicit?
Correct.
But if you're at a United States Attorney's office, you can't solicit, participate. Can you show up at a political event after hours?
After hours, any federal employee can attend a political event.
Can their name be on a host committee?
They cannot, including, so what I was going to explain was that in terms of the union exception, the solicitation is only specific to the union's PAC and cannot be directed at anyone that's a subordinate. So in terms of, let's say, a fundraising event where there's a host committee, typically even union members will not be able to be listed as a member of the host committee.
I'm still trying to understand why there would be an exception for federal labor organizations. Could you hazard a guess?
I could try to hazard a guess if I did some more research and maybe we supplemented a response after today's hearing.
Mr. Chairman, have you been able, you're the most knowledgeable person I know, is there a
If I'm your reference on that, we're not in good shape here.
Well, I might be able to
Gentleman from
eliminate a little bit. Back in 1990, up until 1993, I believe, the United States Postal Service was prohibited from any postal worker from getting involved in a campaign at all. At that point, letter carriers, clerks, who really had a rather peripheral role in the federal appropriations process, were granted the ability. They were given relief under the Hatch Act. So this may have been something that happened at that time where we basically removed them from limitations on the Hatch Act. This may have been something that happened at that point.
I thank the ranking member. To your knowledge, is it limited to just postal employees, this exception?
No, it includes all federal labor organizations and federal employee organizations that had a PAC in existence in 1993 when the act was passed.
Mr. Chairman, can I ask one more question?
Without objection, yes.
I want you to assume that there's a county employee that wants to run for coroner, which is still an elected position in South Carolina. Some people call them medical examiners. Some jurisdictions have forensic pathologists, but we still have coroners. And the office that employs this putative coroner receives some federal grant monies. Does this person who seeks to run for partisan office as coroner have to resign his or her job, take leave without pay, not campaign during working hours? What are the limits, even if it's just a small amount of a federal grant that goes to an office that happens to employ this person? How would he or she be impacted?
Question directed.
Until somebody else volunteers to be the expert.
If the individual has duties in connection with the federal grants that are being received by the office, so that's the first qualifier. It's not enough that the agency receive federal grants. The individual would have to have duties in connection with the federally financed programs. If that is the case, then currently, as the law reads, the individual would have to resign from their state or local employment in order to run for partisan office.
Is there any weighing of how much connection that person would have? Maybe they had 5% supervisory role. Is there, or is it just a bright line test?
Currently, there's some case law in terms of a de minimis exception, and the case law on that point is less than 1/10 of 1% of the person's time in connection. Typically, in the office, we look at 2% or less to be de minimis.
All right. Thank you, Mr. Chairman, and good morning to the Attorney General from the District of Columbia.
Good to see you again.
Two.
Thank you. Thank you. Now recognize the gentleman from Illinois, Mr. Davis, for 5 minutes.
Thank you very much, Mr. Chairman, and I want to thank all of the witnesses for coming. You know, I believe that all of us here believe in the importance of the Hatch Act and in continuing its prohibition on federal employees engaging in political activity while on duty, in the federal workplace or while using federal vehicles. However, we also recognize that new technologies such as laptops and BlackBerries and new workplace developments such as teleworking have made it not always clear to employees what constitutes on duty and the federal workplace. I appreciate the panelists making themselves available this morning to discuss how we can address updating the realities of the 20th century federal workplace and clarify what might be ambiguities in the law. Mr. Lerner, you pointed out that one of the ambiguities in the statute that the Office of Special Counsel would like Congress to address is the definition of political activity. You recommended that Congress codify the definition of political activity that is currently set forth in the Hatch Act regulations. Could you elaborate for us why you believe this term needs to be defined in the statute, even though it's already defined in the regulations?
Well, the Hatch Act regulations currently define the term as, quote, activity directed at the success or failure of a candidate for partisan political office, political party, or partisan political group. That's 5 CFR section 734.101. And we have been using that definition that's in the regulations to define what is political activity. We think that, Congress in 1993 created a bright line rule that prohibited most federal employees from engaging in political activity while on duty, but they kind of missed the step of defining what political activity means. So we've been using the definition that's in the regs, and that's a perfectly good definition. It just seems to make sense that it be codified.
Ian, I'm thinking of situations that I have personally known where individuals may have been working for state government, and there might have been some grant activity from the federal government that funded a part of what it was that they did. I'm recalling one woman who ran for the state Senate, and she was forced to resign from her office, although she did file a lawsuit later on after she lost and got her job back and was compensated. I never quite understood that, but that's what happened in that particular case, and her union backed her, and they won. Mr. Nathan and Mr. Kafina, what thoughts do you have on Ms. Lerner's recommendation?
Well, with respect, my focus is on the District of Columbia, and Mr. Cummings asked the question of what has changed since 1939 when the Hatch Act was passed. And with respect to the District of Columbia, there has been substantial change, because in 1939 we had no elected officials in the District of Columbia. We had 3 appointed commissioners by the President, confirmed by the Senate, and that was the full extent of it. Now, as a result of partial home rule, we have a congresswoman who is elected from the District of Columbia. We have a mayor, we have a city council, we have a school board, we have our neighborhood commissioners, and now the Attorney General's office is going to be elective. And so it's important that so the citizens of the District of Columbia can elect their representatives, that they be allowed to run, whether it's in a partisan or nonpartisan election. Don't think it makes any difference, and that the people who are in those offices or in other offices in the district can run. And so our main focus here is on ensuring that the District of Columbia, under the modified Hatch Act and the reforms that you pass, are not considered to be an executive agency of the federal government, but a state or local government, and that we be allowed to run in partisan elections as local officials should be as well.
Thank you very much, and thank you, Mr. Chairman.
Thank you. That will complete our hearing today. I would ask the members to, if they have additional questions, to send those supplemental questions to the panelists within the next 7 days, and I'll ask the panelists to respond accordingly. With that, I want to thank you for taking the time today on this very important issue, and this subcommittee now stands adjourned.
Thank you.